and Kiyoshi, are you ready for those matters?
Yes, Your Honor.
Okay, so this will be 22300254008. I have these as number 10 and 11 on our docket. And Ms. Looney is the state appearing on these as well.
Yes, Your Honor, we're here to present a child support order as well.
Okay, great. Let me jump into the digital file here. Let's see, and do I have Ms. Vaughn present?
Yes.
Good morning, Ms. Vaughn. Thank you for being here. And Mr. Kiyoshi?
Yes, ma'am.
There you are. I have two, there's so many people. I have two Zoom screens, so making sure I can find everyone here. There we go. Okay, so I believe orders were submitted. Ms. Looney, I do see the proposed temporary child support order. I'm just looking at the last notes when Commissioner Nelson saw you all. He at that time did adopt the proposed child support worksheet. And so my understanding, it was just set on today for presentation.
That's correct, Your Honor.
Is that correct? Okay. And then I also have a note that Mr. Kiyoshi was to pay the GAL fees by today's hearing. So just checking in to see if that's been accomplished.
Yes, Your
ma'am.
Honor. He did come by yesterday afternoon and he paid his portion in full.
Great. I appreciate that, Mr. Kiyoshi. Thank you for being timely with that.
Yes, ma'am.
So let me go through my stack of orders here. All right. So what I have in front of me is the temporary child support order. And as I understand it, Commissioner Nelson did already approve this. Is there any discussion or objections that I need to hear regarding this temporary child support order?
Yes. So I'm not 100% sure. She sent me the worksheets and the support order. So from what I'm understanding, looking at it, is that he would be paying $622 for child support, and then he would also be paying his proportional share of our childcare expenses, which would be $120 a month. But that is to be paid separate to me directly, not garnished through his wages.
And so are you objecting, or are you just asking a question? I'm trying to understand how I can help you.
Questions first. Is that how that works?
So I'm not sure I understand what you're asking me to answer for you.
Is he supposed to be paying the childcare expense to me directly versus going through DCS?
Oh, that's a great question. I'm not sure if I know the answer to that. Ms. Looney, do you know?
Your Honor, it can go either way. If they can work together to have him pay the proportional share directly, they can do that, or she can submit her receipts to DCS and they can help with collection on that amount.
Thank you. Ms. Vaughn, do you have a preference how the two of you want to work on that?
So her audio was completely cut off for that, so I have no clue what she said.
So Ms. Looney, will you try again? And if not, then I'll reiterate.
Yes. So it can be either way, Your Honor. If they can work together and he can pay directly to her, they can do that. Or she can submit her receipts for the child care amounts to DCS, and then DCS can assist with collecting that amount.
Okay, so I would like it to go through DCS. It took him 7 months to pay Beth Fellows her GAL fees, and the only reason I've gotten child support is because it's been garnished at this point. He hasn't ever made any payments reliably on his own, so I'll do that.
And I'm just checking the order. I'm not do I need to check anything specific in order to mandate that it be paid that way, Ms. Looney?
No, Your Honor. We would be looking at section 22. We put the person who pays the expense for that simply because that's the only way DCS is able to assist. If it's paid directly to the service provider, then DCS is not able to assist the parent who's supposed to be receiving the payment in collection. So that's why it's marked as it is.
Great. And I do see that there. So Ms. Looney has filled out this form so that you are the one who receives payments for those expenses, and then it'll be your choice to go through DCS.
Okay.
Submit those receipts, okay?
Mhm.
Any other questions or objections?
Yes,
I'll come to you in a second, Mr. Kiyoshi. Ms. Vaughn.
To
Any
the child support order, no.
Okay. All right, Mr. Kiyoshi, go ahead.
so, yes, so this hearing was set so we can settle the child support obligations. And from what Child Support Services is saying, nothing's changed from the last hearing, $622.
Yes.
The child care, he's already under my insurance. I don't see why I have to pay the child care. She's able to work a full-time job. She chooses not to work a full-time job, and then the babysitter is her sister. That's her roommate. I don't see why I need to put I don't see why I need to help pay that bill. If she can work a full-time job, maybe it might make sense, but it's your sister at the end of the day, and you guys are roommates. You guys share the same bills.
And just, sir, just direct your statements to me rather
Yes.
than directly to her.
Yes, so that's my only concern is the childcare. I don't see why I need to pay into that when she's choosing not to work a full-time job. It says she's worked 35 hours. She can work 40 hours. It's an extra 4 hours or an extra 5 hours. And then on top of that, it's her sister. I have family too that I would love for him to stay over with me, and I have babysitters I have family that can watch him.
During her time, is that what you're saying?
I'm sorry?
You're saying that you have people that would watch during her residential time?
Yes, so that's why we were here to settle the child support obligations, and then I wanted to push everything over until Commissioner David Nelson was actually here, because he's been with the case since it started.
Yep. So I can't give you that option currently. So what I can do is review his prior ruling, which does state specifically court adopts state's proposed worksheets with a transfer payment and set the review and presentation for 6/28/2023 at 9 a.m. My understanding is that he did rule on this. I have separately reviewed it based on the evidence in the case, including the GAL report and documentation received from all parties. I do find that the temporary child support order and worksheet are appropriate, given my independent review of the file and taking into account Mr. Nelson's oral ruling on May 31, 2023. I certainly understand your objection, but what I'm going to state in response is while the child is in residential care with Ms. Vaughn, she will be in charge of deciding childcare. I'm not going to take time away from her to have her bring a kid to you just because it might be a little bit cheaper. If she chooses to use her sister for childcare, probably one of the safest people she could find rather than bringing a stranger in. And 35 hours a week with a lot of employers is full-time.
Yes, ma'am.
So I'm not going to find any merit to your objections at this time. I'm certainly also, though, not taking away your right to make these arguments at trial when you get to your request for full permanent orders, okay?
Yes, ma'am.
Your Honor, I just want to make sure that it's known. I don't work full-time. I don't work 35 hours. The state imputes me at that for exactly what he's saying, that they don't see childcare as a reason to not be working full-time. I don't have full-time childcare. I work 3 days a week and I pay $200 a month for that. Yes, to my sister, or otherwise to my best friend, who is also my roommate. It's been discussed several times over the last several hearings that I do not work full-time. They are imputing me at full-time. So just that.
Absolutely understood. And again, I'm not taking away anyone's ability to argue these issues for your full orders. I think that the written materials that I'm relying upon in signing these orders temporarily support that these orders are appropriate. Anything else we need to do on this case? I only have the child support orders. I just want to make sure I'm not missing any other orders that needed to be reviewed today.
I do believe, Your Honor, this is the GAL, is that we were to also look at whether or not the father had started engaging in the domestic violence treatment,
Okay.
as well as potentially visitation. My understanding, he has completed the evaluation. There are treatment is recommended, but at this point in time, my understanding is that he has not started engaging in that treatment.
Okay. Thank you for bringing that up. I do also see that in the clerk's notes from the last hearing of May 31st. So yes, at that time, Mr. Nelson did rule that you were to complete recommended DV treatment and parenting classes. Until that occurred, the court was denying any unsupervised visitation. So Mr. Kiyoshi, what can you tell me about the status of those?
Yes, ma'am. So I started the 12-week parenting program. This is why I want to settle the child support and then just present everything to Commissioner David Nelson, because he knows the case. But I have started my treatment, my 12-week parenting program, and the DV treatment, evaluation treatment, is also set in motion. I found a place locally, but I paid the transfer fee to transfer the assessment to Olympia from Spanaway.
For the DV treatment, how much is recommended treatment time?
6 months. It's 6 months.
6 months
for the DV treatment, and then 12 weeks for the parenting program, the parenting club.
And forgive me if I didn't hear you correctly. Are you waiting to start both of those, or have you started
So
one?
I've started the 12-week parenting program with Family Education and Support Services.
Okay.
The DV treatment, I did the assessment with alternative counseling, which was in Spanaway. I did research to see where I could get my treatment done and found a place here. Also alternative counseling, but it's local, so I'm not driving the 5 every week to complete treatment. And that and I have an appointment on July 11th at 11 a.m. with Cynthia Norris to complete the intake process, and then they'll have me start on treatment Wednesdays from 6 to 8 p.m.
Okay. Here's my thought, and I'll make sure this is something that Ms. Fellows agrees with in terms of we can actually do this. My thought is, I understand that you're requesting unsupervised visits. I wouldn't be inclined to grant that until we have a little more treatment under our belt, but I do appreciate that you're starting that process. You're taking the right steps. My thought is to set this over, and Ms. Fellows, are you able to access the treatment reports from those visits or not? I mean, because here's my thought is, like, I would love to see progress updates that, you're in good compliance and the provider says you're engaging fully in treatment, taking responsibility and learning and those sorts of things. Ms. Fellows, what's your thought?
Yes, I was going to request that the father sign the appropriate releases of information so that I can access that information, compliance reports, and talk to his provider as needed to get those updates. At this point, yes, those are things that need to be and this has been, I will admit, a very long process. I was appointed in September of last year. This treatment and evaluation and everything else has been ordered for many, many months now. So it's great to see Mr. Kiyoshi is starting to move forward. But we also need to have some of those at least a couple of months in treatment before looking at changing the visitation.
So, thank you, Ms. Fellows. I appreciate that. Mr. Kiyoshi, I do think if you want me to, or a commissioner or judge to re-review visitation, I would make a request that you sign a release of information for those compliance progress notes to Ms. Fellows so that she can make a recommendation to the court when this comes back on. So my thought is to have you do that, and then we set this for review about 2 months out and see where we're at, and we can readdress whether a change in any visitation should occur at that time. What's your thought, Mr. Kiyoshi?
I've done everything the court has asked me, and I'm continuing to do what the court has asked me. Not once since the protection order has been put up have I gone near her. I just want to be able to raise my son, and I keep saying this and I keep repeating myself, but I'm not heard.
Well, I'm hearing you. I'm also taking into account that professionals have recommended 6 months of DV treatment and parenting classes for you. So I am not, without seeing compliance reports, I am not comfortable changing visitation. So what I am offering you is the option to sign an ROI. Ms. Fellows would then get access to your compliance reports to make sure that, hey, this treatment is doing the things we want it to do, which is helping you be a better parent. And then we come back in 2 months and we can revisit this issue. So I am hearing you. I want to assure you we're taking this in steps, and follow those steps. And I think in the end, you're going to get where you want to be. We just need to follow the steps. So I am going to reset this to August 23rd at 9 a.m. if that works for the parties.
Yes, Your Honor. I'm sorry, August 27th?
23rd.
Sorry, okay. 23rd.
And what I'll note, depending on which commissioner is hearing it at that time, what I will just specifically note is that what we're going to be looking for is there an ROI in place for Ms. Fellows? Has she received any compliance reports? And kind of what is her take on visitation based on those compliance reports with treatment? Okay. And certainly, Ms. Vaughn, you will be able to state any objections or agreements to any changes in visitation. We would not do it unilaterally. You will still have very much a say in this. Okay.
Yep.
Thank you. Anything else on this case we need to address?
In the meantime, he does get one virtual visit per week, which is typically Wednesdays at 6. So if he's going to be having treatments Wednesdays from 6 to 8, I'm not sure how we could work around a video visit.
Mr. Kiyoshi, do you need to move the date and time of the video visits?
Yes, that's simple, Your Honor. I can do my treatment and I can call him after. Let's not be here.
What time is treatment over?
8.
How will that, so let me just ask Ms. Vaughn, I don't know what kiddos, sleep schedule is during weeks. Are we running into any issues where we need to set it to a different date, or?
Well, we can't do any other days of the week because he only has Tuesdays and Wednesdays off, and Tuesdays he has his in-person visits.
I work a full-time job.
He's almost 3 years old. His schedule varies. Sometimes he crashes early. Sometimes he stays up a little later. I can do my best to try to have him up and still in a good mood by 8 p.m., but I can't promise that every week it will go that smoothly.
Certain, I think that's very understandable. And I'll just put in the minutes right now that the parties did discuss that the 6 o'clock time will no longer be feasible. The parties are going to work together to use a different time on the same date that the court has ordered. If this becomes a problem, I will issue a new order when we meet in August. Okay, so
And we do
go ahead. Oh, Ms. Vaughn, you froze just briefly if you want to start over.
in the past to call before.
Ms. Vaughn, why don't you turn off your video? I think you're having a bandwidth issue. Just turn off your video and just try to use the audio. And then there you go. We still can't hear you. Can you try speaking?
Can you hear me now?
Yes, we can.
Okay, I said that we do have our family wizard set up per Commissioner Nelson in the past, so we are able to discuss visitation. I know there's been a few Wednesdays he's asked to call before 6 p.m., which might be a little bit easier than after his treatment.
Yeah, I think it sounds like perhaps you two have a bit of a history of working within that same day for the video calls. So I'm just going to have you continue that. So video calls need to remain on that specific day. And then if you want to use the app to coordinate that time, I think that's very appropriate. Sounds like you've been doing this in the past, so I'm not going to issue a formal order to that effect. But again, I will review whether we need a formal order when we meet in August if this becomes a problem. Okay. But thank you both for working together on that. I think, treatment is a high priority, but so is maintaining those video visits. So I wish you both the best of luck in working with those two sometimes competing interests. Okay. All right. And then Ms. Bellows, do I have you on any other cases?
Yes, it is the Weiss shoemate matter.
Yes, I noted this one might take a little bit longer, but let me just check in quickly on other cases, and I'll come right back to you, Ms. Fellows, because I know this docket can sometimes